Welcome to Meet the Professors. My name is Professor Deana Pollard Sacks, and today we're going to be talking about our government's attempts to regulate violent video games to protect children. I have three guests today. I have Craig Anderson, who is a professor of psychology, distinguished professor in liberal arts and sciences, and the director of the Center for the Study of Violence at Iowa State University. He is also a past president of the International Society for Research on Aggression. Fred Galves is also joining us. He is a professor of law and has written 2 textbooks on evidence, among other scholarship. Brad Bushman will join us remotely. He is a professor of communication and psychology and the Margaret Hall and Robert Randall Reinhardt Chair of Mass Communication at The Ohio State University.
Thanks for having me on your show, Deana. It's a pleasure.
Thank you both so much for joining me today. We're going to be talking about our legislature's repeated attempts to regulate violent video games because of the risks they pose to children, and how the courts have repeatedly knocked out those attempts by our government. So Craig, the first question is, how did you get involved? Because I know I've seen your name way before I met you. I saw your name in every single federal case discussing this issue. So how did they find you?
There's several ways I think that this came about. Because of some of our early studies on video game effects on children and adolescents, some of those studies were and still are the most highly cited studies in the area. So anyone doing any kind of a reasonable search for, who knows the research, my research sort of pops up. So I actually get contacted by a lot of people worldwide, legislators, at various levels, to offer basically summaries of what the research shows and what the research doesn't show, and that typically is all that I offer. I mean, sometimes people will ask me to support a particular piece of legislation, right. And I tell them, look, I'm not an expert on public policy. I'm not an expert on legal issues. I am an expert on media violence.
Right.
So, I typically just defer on that part, but I'm happy to tell you what the research shows, what it doesn't show.
Right, and numerous legislatures have tried to, or have enacted legislation to protect children, usually by, regulating sales of these most violent video games to children, but they've been knocked out in the courts. I know there was a case out of Illinois, and then finally the United States Supreme Court decided to take the case out of California. Right. And it was originally called Schwarzenegger versus Entertainment Merchants Association, but then Brown became governor, so the case is now known as Brown versus Entertainment Merchants Association. And in that case, the Supreme Court was having to decide whether California could regulate the sales of the most violent types of video games as to minors. And there were 2 sets of scientific briefs in that case. And I'd like to direct this first question to Brad Bushman. And Brad, can you describe the quality of the experts on each of those briefs?
The U.S. Supreme Court received 2 briefs about the harmful effects of violent video games. One brief claimed that there were no harmful effects, but the people who signed that brief, some of them were actually part of the video game industry, and the other brief said that violent video games can harm children, and the people who signed that brief included past presidents of the International Society for Research on Aggression, for example. And we did a quantitative analysis in which we compared the qualifications for both groups. And what we found is a huge disparity between the 2 groups. For example, the people who signed the brief saying that violent video games harm children had over 48 times more publications in high-quality journals than those who said violent video games do not harm children.
The industry came up with its own, I hesitate to call it a scientific brief because it really doesn't reflect the science at all.
And when you say the industry, you're talking about the merchants, the violent video game manufacturers, Microsoft, and those persons who had a direct financial interest in not having the sales regulated.
Right, exactly. And as you might guess, the industry's brief was filled with half-truths and things that couldn't even be called half-truths. In terms of the expertise of the 2 sides, I mean, perhaps the most telling statistic is, and we later did an analysis, as you know, as one of the co-authors that summarized some of that work. The 13 authors of the true scientific summary published over 338 times more papers in high-quality journals on media violence than the so-called experts hired by the or used by the industry.
Right. Yeah, we co-wrote a piece and then it was published in the Northwestern University Law Review Colloquy, and we compared the two sets of experts because it was so stark. And I was blown away that some of the persons that they called experts in science on the brief in favor of the merchants and the violent video game manufacturers, they sold violent video games for a living, or they manufactured them. They weren't scientists at all.
Yeah, we did a fairly in-depth internet search for all of those people to find out, who they were. And yes, it turns out several worked for video game industries. Some sold basically media violence products. Some were graduate students of some of the other signees. So you have to wonder about independence and coercion and all that. So it was quite a shock, actually, as a person who's not familiar with how the legal system works at this level. It was quite a shock to learn that these people were being called experts.
Right. And Fred, you've written 2 textbooks on evidence law.
Yes.
You've been a professor for 21 years?
Correct.
So is there no qualifications or standards at all for when a person can sign a scientific brief as an expert?
Surprisingly, no, not to sign a brief, because you're not in front of the jury. It's not during trial. Now, when you go to trial, of course, you have to be qualified as an expert under the Daubert decision. It has to be scientific, and there are a number of standards to make sure that it's valid science, and the methodology has to be there. But that's to protect the jury so that they'll overvalue what experts say. When you're writing a brief and it's an amicus curiae going to the Supreme Court, we're assuming those are the experts in law, the Supreme Court justices or judges, and they don't need the quote-unquote protection as gatekeepers to keep them from junk science. So jurors need to be protected from junk science, but judges don't. Now, you run a credibility issue. You certainly can point out that these aren't experts, but there's surprisingly no requirement.
So if a case is for the Supreme Court, I could step in as an NBA expert and I could challenge Shaquille O'Neal and say, I know as much as he does, and he signed a brief and I signed a brief and they're equal. I mean, I could make that argument.
You could make that argument, but it wouldn't be a very good argument, and you'd take a huge credibility hit, and this could be pointed out. But there's no, the rule of evidence goes for jury or bench trials when you're testifying in court.
Right. Well, I'm going to read just a small portion of the statement that was signed by the world's leaders on the effects of the media on children. And here's just the first sentence. Both the American Psychological Association and the American Academy of Pediatrics have issued formal statements stating that scientific research on violent video games clearly shows that such games are causally related to later aggressive behavior in children and adolescents. And you agree with that, right?
Yes.
Because you're one of the signatories on the brief.
Right.
And is it also fair to say that pretty much every single major media effects researcher was on your side of this case?
Oh, exactly. And not only that, but there are a number of other scientific organizations that have issued similar statements to those two.
I was just going to read this. This was put out by the American Academy of Pediatrics, and just so we're clear, this is a nonpartisan organization committed to the benefit of children, the health of children. These are scientists and doctors.
Right.
Okay. This is what they said. Exposure to violence in media, including television, movies, music, and video games, represents a significant risk to the health of children and adolescents. Extensive research evidence indicates that media violence can contribute to aggressive behavior, desensitization to violence, nightmares, and fear of being harmed. The evidence is now clear and convincing. Media violence is one of the causal factors of real-life violence and aggression. The debate should be over. This was in 2009. 2 years before the Supreme Court issued its decision.
Right.
Now what I'd like to do is read to you what the Supreme Court said and just get your reaction. And of course, we're talking about the California law trying to regulate violent video games. And here's what the Supreme Court said, written by Scalia. California relies primarily on the research of Dr. Craig Anderson. Nearly all of the research is based on correlation, not evidence of causation, and most of the studies suffer from significant admitted flaws in methodology. Is that a true statement?
That is not true.
That's not even remotely close to what the experts are saying.
No, in fact, it's false on several counts.
Well, I find that very disappointing. You know, Scalia was joined by a bare majority, right? It was
Right,
Sotomayor.
Well, Kennedy, and then the three female justices,
right,
Ginsburg, Sotomayor, and Kagan, Justice Kagan.
Right. So, and to me, I literally got nauseated reading that, because I have been involved in the research. I've read your research. I've read Brad Bushman's. I've read Ed Donnerstein's research for 20 years. I mean, I could not believe that statement was made by Justice Scalia, and I was even more surprised that he got 4 other justices to go along with it. I mean, I'm kind of partial to Breyer and Breyer's opinion, because he went through the research very carefully and took it very seriously. But I'm not adverse to Alito's opinion. At least Alito, joined by our Chief Justice Roberts, made a careful analysis of the research and ultimately concurred in the decision. But I think that was more because of the First Amendment and how hard it is to regulate any kind of speech once it is considered protected speech. So, another thing that the court did was it compared violent video games to Grimm's fairy tales. And my question for Brad is, what do you think of comparing violent video games to Grimm's fairy tales?
Yeah, violent video games are very different from more passive forms of media. For example, Grimm's fairy tales, although they have words and maybe some pictures, the impact on the audience is much less. And in fact, that's even true for a comparison of violent video games and TV programs and films. There are at least 3 important differences between video games and TV programs and films. One difference is whether the audience is actively involved. In a video game, people are actively playing the game. They have to pay attention to what they're doing, and they actually engage in behavior, whereas people who watch a TV program or a film are much more passive. Second, video games reward violent behavior. For example, you get points for killing people, and that's how you advance to the next level of the game. But nobody pays you money for watching a TV program or film. There's no explicit reward tied to that behavior. And third, if you watch a TV program or film, maybe you identify with the violent character, maybe you don't. But in a video game, you have no choice. If it's first-person shooter, you have the same visual perspective as the killer. You see the violence from the killer's eyes. And if it's a third-person fighting game, you're directly connected to the violent character. In either case, you are connected to a violent character. Therefore, you're much more likely to identify with the character. And lots of research has shown that the more people identify with violent characters, the more aggressively they behave.
Among other things, I mean, just think about the Lord of the Rings trilogy, for example. I read those books with my children when they were fairly young, but think about how many acts of aggression occur, say, per 15 minutes of reading versus how many occur per 15 minutes of watching the movie version or playing the video game version. And just in terms of sheer numbers of acts of violence, they differ.
Not to mention, they're so salient. They're right in your face. Blood is spattering, and most importantly, the child is making the violent acts occur.
Exactly right. And when you're reading, whether you're reading to a child or the child's reading themselves, there's a lot of context, including consequences in terms of most literature. There are consequences, negative consequences, that tend to be the things that get cut out of a movie or a video game because of time constraints and because they aren't exciting.
Right.
But it takes literally weeks of reading that Lord of the Rings set of books, for example, if you're reading for 15 minutes or a half hour a day, whereas you watch the movies in several hours for each movie, or you play the video games for several hours.
Well, one of the things that I found so striking in the case was an older case from 1968 called Ginsburg versus New York. And that was a case where a 16-year-old walked into a cafe and purchased a girly magazine with some naked ladies inside, and the merchant was prosecuted because he sold pornography to a minor. And Fred, tell us about how much evidence the court demanded in that case to hold the merchant liable. The merchant tried a First Amendment defense, and the court said no. And explain why the court did that in Ginsburg.
Yeah, interestingly, the court didn't require any scientific research at all. What they did was defer to the legislature and say that the legislature can make a political decision as to whether this harms children. They seemed to say it was axiomatic. It was just clear.
Common sense.
Yeah.
Sexual content will hurt kids, period, end of story. And court says, I agree. Or actually, court said, we're going to defer to the legislature. They're the body with the authority to do research and to assign research projects to subcommittees and then have hearings and decide what to do. And that's why legislatures are rulemaking bodies, not courts. Right. And in that case, in Ginsburg in '68, the court did what it normally does and defers to the legislature when the legislature makes a determination. But Craig, I mean, the research concerning whether a girly magazine, I mean, we're talking about back in '68, pictures of naked ladies, probably Playboy, something like that. Compare the research showing that harms children to research that violent video games harm children.
No, I mean, the research literatures aren't comparable. The violent video game research, like the television violence research, all of that's much, much clearer. There's very little evidence that nonviolent pornography, or what typically in the field is called erotica, there's very little evidence that nonviolent erotica has harmful impacts. Now, violent erotica has been shown to have harmful impacts, such as increasing aggressive behavior against women.
Right.
But it's the violence that's what's key. It's not naked bodies.
Right. Well, and one of the things I found so striking was I had read 2 other cases handed down by the same court, the Roberts Court, on the issue of whether children are vulnerable to media influences and whether we need to protect them. And in both those cases, the court sided with the government, with the legislature or whatever rulemaking body was trying to protect the children. And it was so striking to me because in Morse versus Frederick, which is where the high school kid rolled out a banner during a school-sponsored event, and the banner said "Bong Hits for Jesus." People know it as the Bong Hits for Jesus case. And he was, got into a lot of trouble with the school. And he raised the First Amendment as a defense, saying, it's speech, Bong hits for Jesus, it's an idea or whatnot. And not only did the court hold against him, but they went on and on about congressional findings and how if children are exposed to that idea, they may go try marijuana, they may get into other drugs, they're more easily addicted, and that is true. Once they do become addicted, it's much harder for them to be rehabilitated. And they went on and on about children's vulnerability and how we need to protect them from this banner on one occasion that said "Bong hits for Jesus." I mean, what do you think of that, Fred? Is that credible to you that they said, oh, a child could, become a pothead by seeing a banner one time, but we have no evidence, or we don't believe any evidence that playing video games for 7 hours a day will affect their brain?
Yeah, it's just the juxtaposition of that is really crazy to think about, because when you're talking about a violent video game, hours, and one thing I was going to point out, that reading is a very passive kind of activity, where these games where it's much more active, you're in the role of the violent person, so it seems like that would have much more of a negative impact. Right. But go back to Ginsburg for a moment. Remember, they've tried to make that distinction between children. Even First Amendment protected girly magazines for adults are going to hurt children. We don't need any scientific research for that. Then to this case where they say, oh, okay, if you're exposed to that one Bong Hits for Jesus, that's just going to make you go out and smoke marijuana. Again, why the difference that it seems like they should just be reversed in terms of the
I
timing.
mean, I agree. I mean, bong hits for Jesus to me is a joke. I mean, no one. I mean, very few people would think they really meant, "Hey, let's go take a bong hit for Jesus." I mean, it's the kind of statement a high school kid's going to make. And it was a one-time thing, and that's what I find so impressive as well.
Well, it's even ambiguous. Is it you're taking a bong hit for Jesus, or do you want Jesus to take a bong hit? So what does it even mean? And it's a high school kid just being a little crazy, I think. So.
Right.
Yeah.
Well, the only obvious white elephant in the room that I can see is in that case it was a high school kid without a lot of means. In the violent video game context, you're talking about multi-billion-dollar corporations, and this court is, I mean, I think, is it fair to say that a lot of law professors feel this is the least credible Supreme Court we've had in the history of the country?
I would say so because it's so politically motivated. I mean, if you look at decisions, everyone knows pretty much how it's going to come down based on the ideology of the Supreme Court justices.
Right.
And it really shouldn't be that way. The law should be separated from politics. We should feel like we go to the law, we could put in our arguments, they're merit-based and they're not politically motivated. Right. Where now it just seems it's result-oriented and it's often on who can pay for it. And these cases are difficult to reconcile unless you look at who the defendant is and you look at the political ideologies involved. And you might say that the justices are more concerned about this when there's not a powerful defendant on the other side, usually.
Right, and in addition to the bong hits for Jesus case, the Roberts court looked at one other case before the Brown case, and that was called FCC versus Fox. And describe that case for us, Fred.
Well, now that's an interesting case, and that goes a little bit against what we were saying because it is Fox Entertainment after all.
But how much was the fine?
Yeah, it
I mean,
wasn't.
in terms of money, there's no comparison. That's what I'm getting at.
Yeah, not big at all. But this is interesting because what happened in this case, there were just expletives. Just Cher and Nicole Richie and the Golden Globes, I think in 2002 and 2003, used the F word and also the S word.
What they call it, fleeting expletives.
Yes.
So it wasn't like they said it over and over again, like George Carlin's famous, song. They used it one time. I think Nicole Richie said something like, "The simple life, it ain't so effing simple. Let's see you get, cow S out of an effing Prada." So it was colorful speech, but it was just one sentence, and that. Before what it was, there was a safe harbor for what they called fleeting expletives, and
because you can't control.
Right, because and the FCC it was told basically they can't control it, but that's kind of beside the point almost, because they did go against Fox in that case, and they said, well, with the new technology you can control it. You have a 7-second delay or whatever it is, you could have gotten it out. But what I find so striking is what the Roberts court said in that case, and I just have to read this. When they held against Fox, and Fox, was raising the same kind of arguments, the court says, quote, "Here it suffices to know that children mimic the behavior they observe. Programming replete with one-word indecent expletives will tend to produce children who use at least one-word indecent expletives. Congress has made the determination that indecent material is harmful to children. If enforcement had to be supported by empirical data, the ban would effectively be a nullity." Is there any way of reconciling this analysis with the analysis in Brown versus Entertainment Merchants Association?
I don't see how you can, because when you take this case and the Ginsburg case, the fleeting expletive or just the girly magazine that is protected First Amendment speech but not for children, and you just say without research, without any basis for this, we just know that this one quick exposure obviously is going to hurt children. But with violent video games, instead of applying that same exact standard and saying obviously it's going to hurt, they'll say even if you have repeated hours and hours of playing this, we're not going to assume that. And you have to bring the best research to prove this. And even when you do bring the best research to prove this, and the other side doesn't bring the experts, or they bring experts who are kind of paid hired guns.
Non-experts, right.
Yeah, they try to act like it's an open question, kind of like global warming or something. If you put the experts on one side and the experts on the other, there's not that much of an argument.
Yeah. Well, not only did Scalia sort of misrepresent the research, but I mean that you really can't do research. And correct me if I'm wrong. You really can't do causal effects research directly on children, because that would mean taking two sets of children, exposing one set to materials we believe really harm them, then watching them to see if they get really harmed. And you can't do that. For the same reason you can't do that sort of research on corporal punishment. You can't take two sets of children, let one kind of live normally and beat the heck out of the other ones to see if they end up really deranged, because that's inherently unethical, right, Craig?
Well, yes and no. Yes, in that you can't do the kind of study on children that would involve real violent behavior. So we can't take a group of say 2-year-olds and randomly assign some of them to grow up in a household that allows all media violence kinds of products to be used, and randomly assign the other half to households where they don't get exposed to a lot of that. And then you follow them up for 5 years or 10 years or 20 years and give them all some guns just to make it even more interesting, and then see which group ends up killing more people. Right? Obviously you can't do that kind of study. But what you can do is the brief exposure kind of experimental study.
But you can't do it on kids.
Oh yes, you can.
Oh, okay.
Yes,
I thought you
can.
used college students for those things.
Well, we use college students, but there are studies with children as well, where they come in fact, one of our key experimental studies that appeared in our 2007 book, we exposed children to either a child-approved type game, that is, games that were designed for children, and half the kids played a children's game that had some violent content in it. So, for example, there was one game that involved invader tomatoes, essentially, and as you were saving the world by shooting these invader tomatoes, and it's all done with happy music and cute cartoon characters, and there's no screaming, there's no blood. The other half played a nonviolent children's game, and then shortly after they got done playing those, whichever game they were assigned to, they were put in a situation where they were mildly provoked. They thought that they were mildly provoked by another child, and given the opportunity to retaliate. Now, again, they're not actually retaliating against another child, it's actually the computer. But they thought that they were delivering harmful punishments to another child. Well, it turns out that those who had just played the violent kids game aggressed against this target, or retaliated at 40% higher level than the kids who had just played the nonviolent game. And in fact, in that same study, we also had college students playing those same games, right? Children's games. So obviously the college students understand, and so did the kids really, that these are fantasy games, that this isn't reality. The college student samples showed the same phenomenon. Those who played the violent children's game aggressed at about a 40% higher rate than those who played the nonviolent game. So you can do, when the content is considered appropriate for children and is at a lower level of violence and it's a brief exposure, you can do the kind of experimental studies that allow very strong causal statements.
Okay, well, we're about out of time, but I think it's fair to say we all agree that something needs to be done. At the very least, parents need to be educated about how serious the risks are posed by violent video games to their children's minds, their physiology, their brain chemistry, and their attitudes and ultimate worldview and what they experience in life. Thank you both so much for joining me here. I really appreciate your time. It's been very informative. I've learned from you just sitting here right now on the spot.
Thanks for having me on. I really enjoyed talking to you about this very important topic.
Thank you for joining us. You've been watching Meet the Professors. I'm your host, Professor Deana Pollard Sacks, and I hope you'll join us again.